Good morning, everybody. Good morning, Jenny, Ed. All right. So let us begin. Let us begin. Can you all see my screen okay there? Can you see my screen where it says Paul Horn, probate attorney? Okay, very good. Okay, so if you have any question, you can type your question in the chat box. Okay, you can type it in the chat box. All right, so the goal of this class is to share with you your homeowner are going to die, period. So when you get that phone call that says, hey, can you please list my mom house, my dad house, they pass away, how would you do that? Mom was your client. Mom has 4 children. Which one of the 4 would have the power to sign your listing agreement? Now, how would you do that? Okay. While mom is alive, mom is your client, you take the listing, and that's easy, right? But once mom is in heaven, who steps in her shoe to sign your paperwork? That's what this class is all about. Okay. All right. So let us begin. So my name is Paul Horn. I'm a probate attorney. I'm also a CPA. We'll get into some tax stuff as well. Almost 99.99% of the time, mom bought the house for $200,000, $300,000. Now you're selling it for the son, the daughter, for $1 million, $1.5 million. There are substantial capital gain. And we're going to talk about that. Are there any capital gain tax? What about the step up basis? What about property tax? So we'll discuss all that as well. So that's where my CPA comes in. We'll talk about that. Okay. And so I'm a probate attorney. I'm a CPA. CPA stands for Chinese Party Animal, right? CPA. Okay, let us begin. So first thing. So the first thing you're going to do, when you get that phone call, mom passed away, the first thing you're going to do is you're going to pull the grand deed. Mom passed away. You're going to do your things. The next moment is you're going to pull the grand deed. And how do you pull the grand deed? Well, you're going to get your title rep, right? Hey, title rep, could you please give me the grand deed on 123 Main Street, Laguna Niguel? When you receive that grand deed, the owner of the house is only going to be in 2 manners. One is in a trust, one is not in a trust. That's it. When you receive the grand deed, there's only 2, there's a fork in the road, and the fork in the road is either going to be in a trust or not in a trust. If the house is in a trust, then there's no probate. The successor trustee would sign your listing agreement. When mom went and drafted her trust, the lawyer would have asked mom, hey mom, you have 4 children. Yes, that house is going to be divvied up 25% to each of the 4 children. But mom, who do you trust? Who do you find is the most responsible person to sign the listing, to carry out your instruction, mom? And that person, we call that person the successor trustee. The successor trustee. If that, and that's it. If the house is in a trust, no probate, successor trustee signs your listing agreement, and on your way you go toward closing escrow. If you pull the grand deed and the house is not in a trust, it's going to go to probate, and the personal representative would sign your listing agreement. So what I would do, if I were you, I would pull out my iPhone and I would take a picture of this. This is it's a good diagram. It's a good diagram that illustrates when someone passed away, they own a house. It's only going to happen in two ways. On the left-hand side of the screen, I diagram out for you what happened. The house is in a trust, how it plays out. On the right-hand side, I diagram out for you the house is not in a trust. It goes to a probate. It goes through the probate process, and the personal representative signs your listing agreement. Okay. So take a picture of that, and we will expand upon this diagram as we move forward. All right, so, okay, so first thing, you're gonna pull the grand deed. If the house is in a trust, hallelujah, you move forward, okay? So who can sign your listing agreement if the house is in a trust? You know the answer. It would be the successor trustee, okay? To confirm who is a successor trustee, you're going to need to see a copy of the trust. Where would you find a copy of the trust? Most likely the children will give it to you. Most likely the children will give it to you, or you can call up the lawyer who drafted the case. Hopefully that lawyer is still alive, right? That lawyer might be dead. Thank God lawyer died as well, right? Thank goodness. So the moral of the story is, for this particular slide, is that keep a copy of the trust. Keep a copy of the trust, okay? Because if you do not have a copy of the trust, let's say the house is in the trust. The grand deed shows the house is in the trust, but you're not able to locate a copy of the trust. The children cannot find a copy of the trust. Then what happened? The house is in the trust, but you just cannot find a copy of the trust. In that scenario, the phrase is, too bad, so sad, welcome to probate, okay? So if your client lost the trust, mom died, it's going to go to probate. So make sure you have a copy of the trust. All right, so when I say make sure you have a copy of your trust, normally when you go draft your trust, the lawyer is going to give you a binder like you see on the screen, and that lawyer ought to give you an electronic copy as well, okay? So now let's get into the essential component of a good estate planning. So far we covered, hey, the trust. You pull the grand deed, a homeowner died, it's your client, you're going to sell the house, you're going to pull the grand deed. If the house is in a trust, no problem, no probate. Successor trustee signs your listing agreement. Okay, so that's the trust. So now, the next thing that's very important is the durable power of attorney. So I want you to imagine this. You're out on a listing appointment, husband and wife. Husband has dementia. Husband has Alzheimer's. The wife signs your listing agreement for you to sell this house. Her husband is unable to sign anything because he has dementia. So in that scenario, you're going to ask for the durable power of attorney. The durable power of attorney says, hey, if I'm incapacitated, I trust my wife to sign my name. I trust my son, my daughter to sign my name. Okay, so if you're out on a listing appointment, husband or wife, if either of whether the wife or the husband, if one of them has dementia, Alzheimer's, incapacitated, you can still move forward, but you're going to want to see the durable power of attorney. The durable power of attorney is a document that's specifically draft for that particular situation, where if someone's incapacitated, the power of attorney, whoever is named as the power of attorney, is going to be able to sign your listing agreement. Specifically, that's the durable power of attorney. So if we go back to my list, on the screen is what is a good estate planning legal documents. The trust avoids probate. The durable power of attorney deals with incapacity. Number 3, the advanced healthcare directive. A lot of time sometime, right? You're in the hospital, you're not able to speak or talk. Who do you trust to speak on your behalf? That's the advanced healthcare directive, speaking to the doctor, speaking to the hospital. Number 4 is pretty important. Number 4 is known as the pour over will. So what that is this. Let's say you have a trust. The lawyer vested the house in your trust. While you were alive, you refinanced the house, and the house inadvertently is removed from the trust. Now, you pass away. So inadvertently, there's a trust, but the house is not in the trust. Can you avoid a probate? The answer is yes. There's something known as the pour over will that says, hey, everything I own pours into my trust. So that's known as a pour over will. So that's why I show you this list. This is an important list. Take a picture of this list. If you have an estate planning, you want to make sure you have all these documents. Number 5 is a trust transfer deed. When you create a trust, there's going to be a brand new grandee to make your house owned by your trust. So how a trust works is that you have a revocable trust. The house goes in your trust. As long as you are alive, you are the trustee. Once you pass away, the successor trustee can sell the house. That's how we get the house into your trust via number 5 on the screen, the trust transfer deed. And then all your cars, all your personal property goes into the trust as well. If you have an LLC, a corporation, all those goes into your trust as well. So take a picture of what's on the screen. That is an important list And you might want to go back and check if you have a trust, go back to your trust and check to see if all these are there. All right. Let's move on. So let's talk about vesting for a second. Well, before we talk about vesting, let's do this. Let's talk about the step up in basis. Okay. So the house is in a trust. Mom bought it for $250,000 in Laguna Niguel. She bought it for $250,000 40 years ago. 40 years ago. 40 years later, she passed away. The house is worth $2 million. When you sell it for $2 million, there will not be any capital gain. Okay, so no capital gain. If the children, the son, the daughter, or anybody receive the house after the decedent passed away, there's something known as the step up in basis that will wipe out the capital gain. So it's very powerful. You can take advantage of this step up in basis concept and not have your children pay any tax. The only thing you need to do is do not put their name on to your grandee. Do not make the mistake of saying, oh, I only have one son, I only have one daughter. Why don't I put their name onto the grandee so that when I pass away, the house automatically go to them? Don't do that. Put your house in a trust. When you die, the house appreciate in value, 5x, 10x, doesn't matter. There's a concept known as the step up in basis. You can find that in the Internal Revenue Code section 1014 that addresses the step up in basis. So to make a long story short, when you're selling a house for a son or daughter, if everything is done correctly, there will be no capital gain. Mom bought the house for very cheap. The house is in a trust. You sell it, no capital gain, known because of something known as a step up in basis. Okay. Now, so that's capital gain. Okay. So as a married couple in California, if you are a married couple in California, you and your husband, you and your wife, when you buy a house, you can vest it as joint tenant. You can vest it as community property. You can vest it as community property with right of survivorship. These are the three ways of vesting title. Okay. So what I want to teach you is when you're buying a house and you live in California, California is a community property state. The option on the screen is how you can take title. But I want to share with you that if you were to take it as joint tenant, you don't get the best tax advantage. Okay. Let's say a married. So before I start on this, just think about this. Husband and wife have a bunch of rental property. When the husband dies, the wife can sell any of the rental property and not pay any capital gain. So let me repeat that. Husband and wife are going to buy a bunch of real estate, a bunch of rental property. Husband die, right? California law, husband always die first. When husband die and the wife needs to sell one of rental property, there will be no capital gain And that's going to depend on how they vest title in that house. If they vested as joint tenant on the screen, I have an example for you. Let's say they bought that rental property for $100,000. 40 years later, husband died. It's worth $1 million. The wife sells that house for $1 million because it's under joint tenant. There's only a half step up in basis. So the capital gain on that rental property is $450. But if it's under community property, it's 100% step up in basis. So rental property, husband and wife, if they were to vest that house as community property, when husband died and the wife sells that house, no capital gain, even though they bought that house a long time ago for a very cheap price. Okay. So on the screen is a very important concept. You and your wife are buying a house. You and your husband are buying a house. And you live in California. If you want 100% step up in basis upon the first spouse to die, you should vest that as community property. So in California, you can either vest as community property for a married couple, or you can vest as community property with right of survivorship. What's the difference? The difference is this. If you only vest as community property, just community property only, your wife can will her half to that pool boy because he's an amazing pool cleaner. But if you were to vest it as community property with right of survivorship, that's where neither party can will their half away. That's called the I love you way of holding title, the third column. So if you're married, it is indeed community property, money. You should vest it as community property with right of survivorship. So this is a very good screen to take a picture of. What I'm going to do is this. I'm going to share with you a little video that I put together. If you ever have a buyer, that says, hey, you know, I'm not sure how I should vest. Escrow has given me these forms, and escrow has asked me, the buyer, to if I want joint tenant, if I want community property, tenant in common, I'm not sure. This is a great video that I put together to go over what I just explained to you. So what I'm going to do is this. I'm going to drop this link. I'm going to drop this link into the chat box. Let's see. I'm going to drop this link in the chat box. If you click on this link, you can use it later. If you wanted to share with your buyer, or if you wanted a review on this. Before I take some question, let me go over one more concept with you. Let me go over joint tenant with you. Joint tenant. All right, let's talk about joint tenant. So joint tenant, I'm pretty sure a lot of you know of a lot of homeowner under joint tenant. So let's talk about joint tenant for a second. Joint tenant, okay? So on the screen, joint tenant. Joint tenant, you buy a house for someone else and it's joint tenant. So let's say mom and dad owns a house and joint tenant. If dad died first, how is the house going to pass to mom? mom simply file an affidavit death of a joint tenant. She does that and the house goes to mom. The problem is this. Here is the problem with joint tenant. Joint tenant can really have an adverse effect in certain situations. So let's do an example together. Let's say we have Jane, who is 80 years old. She's a high producer, she's a realtor, high producer, makes lots of money. She's gonna buy a $5 million mansion house as joint tenant with her new husband, Rico Suave, the guy you see on the screen. He doesn't have a penny to his name, but that's okay. He's got a six-pack, right? So we're all good. 25 days later, Jane died. Happy ending for her with a smile in heaven. Who gets this house? Because it's under joint tenant, it all goes to her new husband, Rico Suave. Nothing to her daughter, nothing to her son. So be careful with joint tenant, okay? Joint tenant can have some really adverse effect. Okay. All right, now let me take some question. If you raise your hand, I can unmute you. So raise your hand and I'm gonna take your question. Anybody want to speak? Raise your hand and I'll unmute you. Okay, so I think I can unmute you, right? Just raise your hand and I'll get your question. Okay, so yeah, if you raise your hand, I'll come and I can unmute you and you can ask your question, or is that not possible? Okay, so in the chat box, Mario asked me, what are the advantages and disadvantages of an irrevocable trust? So there's two types of trust, a regular trust, a revocable trust, and an irrevocable trust. Irrevocable is no longer your house. So if you put a house into an irrevocable trust, that house no longer belongs to you. So 99.99% of you out there do not want an irrevocable trust. Estate planning attorney like myself, we use irrevocable trust to beat estate planning, to beat estate tax. If you and your wife have more than $27 million, the first $27 million for a married couple is tax-free. The estate tax is 40%. You and your wife are worth 30 million bucks. When you die, the first 27, no estate tax. The $3 million between 27 and 30 gets taxed at 40%. So if you're worth $30 million, we created an irrevocable trust to siphon out that $3 million so that when you die under the $27 million estate tax exemption, and there'll be no estate tax. So the only time, the common reason we entertain an irrevocable trust is to beat the estate tax. Yeah. Any question, guys? If you raise, Gene, you say I don't see hand raised. I guess you're not able to raise your hand. Is that the story? Can I unmute? Oh, you're not able to raise your hand? Okay. All right. I wonder why, huh? Let's see. Okay. So I'm gonna try and unmute Dee. I'm gonna come and I'm gonna try this. So can you talk, Dee? Are you able to unmute your mic, Dee, or no? No? Okay. Um, so you're not able to speak, huh, Didi? Hmm.
Hi, Paul. Yeah, nobody's able to speak, but I can allow if you want me to do that, I can enable the raise hand feature and then allow them to speak.
Yes, please.
Okay, so give me just 1 second, everyone, and I'll allow you guys to raise your hand. I'll put it in the chat when it's ready.
That would be great. Thank you. Yeah, yeah. So yeah. So while we're working on allowing you guys to speak through your microphone, ask your question. Um, Katrina says, can you explain why putting a child's name on a grandee is a taxable event when a parent dies? Yeah. So Katrina, you don't want to put your son's name, your daughter's name on your grandee because they don't get to step up in basis when you die. Because when you put your son or daughter on the grandee, you have given them that house while you are alive. And if that's the case, they don't get to step up in basis. Okay, so let's try it now. Let's see. Let's try Didi. Didi, are you able to raise your hand? And I'll come and unmute you. Oh, here we go. Hi, Didi.
Okay, hi.
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 Yeah,
So,
did you have a question?
yeah, I have a couple of clients that they have purchased, say, 3 units, plus they have their single family home. They might want to purchase additional single families in the course of this year. So how would they hold title in, what's the best way to get them started with a trust? Because she's an unmarried woman with children and
Okay.
grandchildren.
Yeah, so she's unmarried, so all she needs is put it in her trust. When she died, and if her children were to sell any of those houses, there'll be no capital gain. She would get the children will get a step up in basis. So tell your client, just put it in a trust. Do not give any of the houses to the children while she is alive. Wait, put it in a trust, and the trust would say, okay, you get my house when I die. And when they get it, they get to step up in basis, Didi.
Okay, thank you so much.
You are welcome. All right. Let's see. Hi, Rebecca. I see you have your hand up, Rebecca.
Yes, I have a question.
Yeah.
Yeah, if wife and husband with 2 children on the title with tenant in common and as their prime home, they want to sell the house, can each person enjoy 250 exemption?
Only if they live there.
Yes.
Only if that's their primary residence.
Okay, that's true. Okay. And if they want to sell the house, and the right now because I have another question, and because the too many the recently the house price increased a lot, and some parents want to sell the house instead to pass the house when they die. And they want to sell the house and the investment on another house and to upgrade the house, maybe whatever. So if they add their name on it, and 4 people live there with their children, and 4 people live there, and any what kind of tax implication will be affect both of them?
Yeah. So they all have to live there 2 out of the last 5 years.
Okay.
All have to live there 2 out of the last 5 years to get the $250,000 capital.
Okay, but they will be have possibly they get assessment of a property, increase the property, and
That's true.
also maybe they also need to file the tax return, right?
Yeah, I'm not too worried about the gift tax return because during your lifetime, you are allowed to give up to $13.9 million. Okay.
Reside, okay.
Yeah. So in your situation, Rebecca, and that particular scenario, I would have them go talk to the CPA, sit down with the CPA for 1 hour, 30 minutes and talk. That's what I would recommend. Okay.
Okay.
All right, thanks. Let me unmute Katrina Crawford. Hi. Katrina, or maybe Stephanie. Hi, Stephanie or Katrina.
Yeah, hi, can you hear me?
Yes, I can.
Hi, Paul. Thanks for taking my question. You touched on irrevocable trust. Can you also go into the differences between a regular trust and a revocable trust?
Yeah. So the majority of trusts out there are revocable trusts. They're like 99.9%. Irrevocable, when you put your house into an irrevocable trust, you no longer own that house. It's no longer your asset. And because you need access to your house, having an irrevocable trust would not be ideal. So your question to me is going to be then, Paul, why do people have irrevocable trust? We use irrevocable trust for estate tax planning. Right now, Katrina, you get 13.9 million if your wealth. When you die, if you die less than 13.9 million, no estate tax. The estate tax is 40%. Let's say you, Katrina, you're worth 20 million. You're single, you're worth 20 million. You're a single person, you're worth 20 million. When you die, this is call it 14. The first 14 million, no estate tax, no estate tax. The difference between your 20 million and the first 14 millions is free. That's 6 million is taxed at 40%. So to avoid you paying 40% of that 6 million because you're worth 20 million, we create an irrevocable trust where because you have 20 million, you're able to afford to siphon out asset that you don't need. You don't need $20 million to live on. So we can put $6 million away into an irrevocable trust where it's going to go to your children, your grandchildren, whoever you want, so that when you die, possibly you don't need to pay any estate tax between them. That's the difference between revocable trust and irrevocable trust and why the two exist.
Thank you. And how about a regular trust?
That's it. The majority of people, more like common guy, mere mortal man like myself, I don't have more, my wife and I, we don't have more than 27 million. We just put our houses into a regular trust where we can use it, we can sell it, we can refinance it, we can change the trust. So the 99%, you and I and everybody else out there, a regular trust would do. You don't need an irrevocable one.
Thank you.
You are welcome. Let's get to Stephanie. Hi, Stephanie. Hi, Stephanie.
Unmute. Hi, can you hear me now?
Yes.
There we go. Are you gonna talk at all about like the process when court confirmation is required? Like how that's different? I know that I've seen a few of those come up and I've done it where there's no court confirmation required, but once there's court confirmation required, how does it look different from like a buyer standpoint or a listing agent?
Okay, all right. Here, why don't we get into that now? Okay.
Okay.
Why don't we get into that now? So going back to our okay, so it'd be a great idea if you guys would take a picture of this screen right here. This screen on the left-hand side, we've gone over already. On the left-hand side of the screen, if the house is in a trust, no probate needed. Now we move to the right-hand side of the screen, where the house is not in a trust, a probate is needed. And in a probate, the personal representative signs your listing agreement. Every single probate is either going to be with full authority or limited authority. If it's full authority, you do not need the court permission to sell this house, aka court confirmation. If it's full authority, all you need is to give escrow a form called orders for probate, a form called letters, a form called the notice of proposed action. Okay. A probate takes about at least a year. Okay, a probate takes about at least 1 year to complete. What I want you to know is that you're able to sell this house while the probate is active. Every single probate is either going to be full authority or limited authority. Limited authority requires court confirmation. Full authority does not. 90% of all probate cases out there are full authority. If it's full authority, all you need to do is this. I'm going to bring up a slide that says, hey, if your case is full authority, you only need to give escrow these 3 forms. I'm going to show it to you. Let's see here. Let's see if I can show you the screen. So 90% of all probate cases out there are full authority. And if it's full authority, do this. If it's full authority, you just need to give escrow, a form known as the order for probate, and a form known as letters. First thing first, probate takes a year to do. It takes the probate attorney about 3 months to get you these 2 forms known as order for probate and letters. Let me show you what these forms looks like, okay? The first, this is a very important form. Mom died, mom has 4 children, no trust, it's in a probate. How do you know which son, which daughter has been appointed by the judge? And how do you know whether full authority or limited authority is granted? You want to see the form on your screen, okay? You want to see the form on your screen. It's called order for probate. Can you guys see that form that's on your screen? It says order for probate. Can you all see that? So in a probate case, if you're the listing agent or even the buyer, representing the buyer, you want to see that. That form on the screen, if you look at numeral number 4, if you look at number 4, it's going to have a check. It's going to say full authority or limited authority. So if you represent the buyer on that probate and you want to buy that probate house, you represent the buyer. And if there's that form that the listing agent give you, if it's checked full authority, there's no court confirmation. If it's checked limited authority, that's when you have court confirmation, okay? For now, I want you to know, if you are the listing agent, probate takes a year to complete. About 2 to 3 months into the probate, 2 to 3 months after the probate attorney has filed your case, that lawyer should give you the first form that's on your screen and the second form known as letters. Once you have these two forms, you can accept an offer. Once you have an offer, once you have these two forms, accept an offer, give the offer to the probate attorney, he then will generate a third form known as the notice of proposed action. The notice of proposed action. 15 days later, you can close escrow. Okay, so what I just explained to you is how you would maneuver in selling, handling an escrow for a probate transaction that is full authority. On the screen is a very important diagram. Take a picture of it. So what I just explained to you is a full authority probate. Now, let's move on to limited authority. This is the other 10% of all probate cases with the unfortunate situation where limited authority is granted to that son, that daughter. Okay. To answer the last question someone asked me, focus your eye on these 9 steps. It's your probate case. You're the listing agent. And it's limited authority. This is your checklist right here. Number 1, that lawyer is going to give you the order for probate that says, yeah, so-and-so has been appointed as the personal representative with limited authority. The lawyer is going to give you a form called letters. We saw that what that form looks like. Because it's limited authority, and because we're going to sell that house, the lawyer is going to publish in a newspaper that says, hey, we're selling the house. After and only after the newspaper publication is done, then you can accept an offer. That's number 4. I numerically list that out for you. Only after publication can you accept an offer. And when you accept an offer, the buyer put 10% down. Clear all contingency. The lawyer will now put together a petition for court confirmation. The probate attorney is going to say, hey, judge, this is a limited authority probate case. Hey, judge, we have a buyer. Hey, judge, we've done everything that we need to do. It's been published in a newspaper. We have a buyer that's put 10% down. That buyer has cleared all contingency. We're ready to go. The judge will give a hearing date to confirm that sale. That hearing date is the court hearing date. Other buyer can show up. Other buyer can show up to bid on that house. Okay. Other buyer can show up to bid on that house. That's called the overbidding process. In court, the listing agent shows up. The selling agent shows up. The original buyer show up. Other potential buyer descend in the courtroom to bid on this house. Whoever is the winner, the judge will issue an order that says so-and-so won the bid, the house go to so-and-so. And that's how, after that, you close escrow. I'm not sure who asked me that question. Did that answer your question? Was it Stephanie that asked me that question? I'm not sure who asked me that question. How
Yeah,
the
that answered. Thank you.
Yeah. Okay. All right. So if you show up in court to bid on a house, you better bring a 10% cashier check. 10% cashier check, okay? And the lawyer, the probate attorney is not gonna let you bid on this house unless you have a 10% cashier check. Yeah. Any question, guys? Just raise your hand and I'm gonna come around to unmute you. to answer your questions. Let's see. Hi, Robert. Robert? Or Grace? Robert or Grace?
Can you hear me?
Yes, I can.
Okay, so on the bid, when you say that people can bid, is it one bid and like highest and best, and they just take the highest, or is it more auction where they, put it out there and people can see where the other bid is and see if they want to go higher?
Okay. Okay. Yeah. So here I actually had a live one this morning. I actually have a real example from this morning in court. So let's just recap. Court confirmation, limited authority. You have an offer. We're going to go to court. They call court confirmation because it's limited authority. There's an accepted offer already on the table. In this example on the screen is 810. Okay, 810. We tell the judge, hey judge, we have a buyer for 810. And the court has a formula. On the screen is the formula for overbidding. So we have an original accepted offer for 810. If no one else shows up to bid on this house, that original offer takes it, that original buyer, that original accepted offer takes it at 810,000. If other people show up to bid on this house, what is the starting bid? There's a formula. If you look at the screen, that's the exact court formula. The original accepted offer is 810. We're going to take 10% of the first 10,000 is $1,000. We're going to take 5% of the remaining. In this scenario, it's going to be 40,000. So the court would start the bid at 851. The original accepted offer was 810. Because other people shows up that wants this house as well, the court will start at 851. 860. Do I hear 860? Do I hear 870? 880 and so forth. That's how the overbidding works in court. Does that answer your question?
Yes.
Yeah. Yeah, if you have a question, just go ahead and I guess, yeah, Grace, you have a question, Grace? Hi, Grace.
Hi, yes, good morning. Thank you for taking my call. Oh, quick question. Would you mind showing the slide, the third slide after the letter, the accepted offer? I didn't have a chance to take a screenshot of that, please.
Yeah. So just to recap a little bit, this is a great diagram to take a picture of. In red, I illustrate out for you, I diagram out for you, how would you handle a probate listing. In the middle, I said that, hey, every single probate case is either going to be full authority or limited authority. In the middle, I showed you, hey, if it's a full authority probate case and 90% of all probate cases are full authority, you follow my diagram, you only need to give escrow 3 forms to close a full authority probate.
Yes.
One of them is called order for probate. The next one is called letters. It's a form called letters. The third one is called a notice of proposed action.
Yes.
The notice of proposed action. And that is exactly the name of the form. It's called the notice of proposed action. Is that what you were looking for?
Yes.
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 Great. All right. Yeah. Hi, Quindin. You have a question, Quindin? Hi, Quinn.
Hi, can you hear me?
Hi.
Just a quick question. You talk about the newspaper and the publication. Is this a special publication that?
You don't worry about it, Quindon. The lawyer does it for you. Don't worry about it.
No, I'm just curious where you find this list.
It's basically it's a city list. It's it's a list that's published in a legal newspaper. Let's say, what city do you live in, Quinn?
I live in Costa Mesa.
Good, Costa Mesa. Yeah. So generally, let's say someone died in Costa Mesa. They don't have a trust. It's a probate, and let's say that probate is limited authority. This house to be sold. So normally it's one of the local newspaper in Costa Mesa that's going to publish it. Okay. Yeah. Okay.
I didn't think newspaper exists anymore, but anyway.
They do. It's and a lot of stuff the government do, Quinn, that doesn't make sense, but they make you do it, and that's part of your answer. Yeah. Okay. Yeah.
One more quick question for you with the limited authority. So if you list the property and let's say immediately you end up with multiple offers, who chooses which offer is accepted and what makes it that offer is accepted? Is it always price? Is it terms?
Okay.
How does that work if you have multiple offers? Who chooses?
Okay. So when you are the listing agent on a probate case, and realtors are always wondering, well, what price should I list it at? What price should I list it at? What's an acceptable price? The starting point is, I always tell them, is pretend this is your house. This is your house. How much would you list it for? This is your house. You want to get the best price. How much would you list it for? So you start off with that principle. This is your house. Quote unquote, imagine this is your house and you want to get the most money. How much would you list it for? If you go with that fundamental concept, you can't go wrong. Now, here's what happened. Every single probate case is assigned a probate referee to value the house. If the probate referee value the house at $1 million, if it's limited authority, the selling price must be 90%. That's kind of the technicality of the rule. It's a probate house. The comp shows it's worth $1 million. But let's say there's 50 years of deferred maintenance, meaning the house is so old, it needs a lot of repair. It's like $200,000 worth of repair. And there's no way that you can sell it for $1 million. There's no way you can sell it for $900,000. So if the house is in bad shape, you're going to take photographs, you're going to take cost of repair, give it to the probate attorney so he can give it to the probate court, to the probate referee, so that the value can be more in tune, in alignment with the real value of the property. Having said the technicality, if you go back to the concept, this is your house and you want to sell it for the highest price possible, if you go with that attitude, you cannot go wrong. Further question on that, please? Did I answer your question?
No, the question was, I understand that point. I understand that there's a base, like an appraisal, a value given to the property. But if you end up with let's say 2 people come in and you have 2 offers, who chooses which offer gets to move forward to release their contingencies to then try and go to court and purchase that home? How is
the personal representative choose the offer?
But if it's limited authority, is there still a personal representative, or is
Oh,
then
yes, there's always a personal representative. Someone's got to be in charge. One of the son or daughter will be in charge.
what if there is no son or daughter? If there's no family involved, this is straight with the courts, then
Nope, nope, nope. It's never served with the court. Someone will be in charge, whether it be a lawyer, where it will be a personal, whether it be a trustee. Someone died, no wife, no children,
okay.
no brother, no sister. We can trace it all the way back to Adam and Eve and find someone who's related that's going to take that property.
Okay.
And that person's going to be in charge.
And then how do they choose? Does it always go based off price? Or if you have like a cash offer that's less, does that win out? Sometimes it wins out in a normal scenario. How is
Yeah,
that?
so it goes back to the best offer. If there's a cash offer, common sense, right? If there's a cash offer for 300,000 and the profits were 700,000, that ain't gonna be a go. You know what I mean? So yeah, it normally is the best choice, the best offer.
Okay. Thank you.
But you would have a tough time saying that that $300,000 cash offer is and the house is worth 700,000, that's the best offer. So yeah, so go back to your, do what you do best, which is, this is your house. Which one would be the best offer? It's a cash offer for 650. The house is worth 720, but there's a foreclosure. There's another offer that's a loan for 700. Then I can see how that 650 cash would stand in court as the best offer. Does that make sense?
Yes. Yeah.
Yeah.
I've had clients ask this question because there have been some of these where there's a limited authority, and the question is, well, how do I know that I have the best offer, or is it always based off price? Because when I represented I had a listing that had no court confirmation required, and so I dealt with the probate attorney and the son. It sounded like it was always what would net the most was the offer that won, not necessarily the cleanest offer. So if I have a $700,000 cash and a 710 with a loan, the 710 would beat it out because it is going to net more.
And that's true, but let's say there are other competing issues on the table, like a foreclosure, that would come into play. Let's say, for example, there are tenants in there, and that the one that's 10 grand less is willing to take it with the tenant in there, for example. So there are a little bit of factor here and there, but you're on the right track. Whatever nets the most, and it's common sense, yeah. Hey guys, it's 11:01. I want to thank you, all of you, very much for being with me today. I think this is recorded. Yes, it is recorded, and you can see it on YouTube. My PowerPoint has a bunch of legalese in it, so it's not going to be sent out to you guys, but just watch this video over. Go to my website. If you go to my website, paulhornlawfirm.com, I have a bunch of terrific video on there that you're able to get. So thank you so much for being with me. I don't want to go over time. Right now it's 11:02. So thank you for being with me, guys.